Hello, fellow Toolboxers. Welcome to episode number 367 of the Immigration Lawyers Toolbox podcast. It's the top 10 episode, and it's really like top 14. So I have like subcategories, sub stuff to fit it in because I'm supposed to do these monthly, but it's going quarterly. So I want to get some really important ones out there so you get it. Really good information of stuff I've learned that's helpful for the practice of U.S. immigration law. Before we start, some housekeeping. We're doing a regular monthly E2 seminar now, going through concept processing, change of status, how I walk through cases that I've done. And I know it's good because we have just returning students. People saw another one, want another one. So it's just, you could tell that they're down with it. And I'm prepping a national interest waiver session. I know a lot of people are interested in that. That's probably going to be in April. The next E2 one's on March 20th, and lawyers only. And it's $300. And the NIW one's going to be in April, probably third week of April. It's our Thursday, 10 a.m. Pacific, 1 p.m. Eastern time. We have a registration page, but it's like a long thing. So just email me at info@immigrationlawyerstoolbox.com. info@immigrationlawyerstoolbox.com to get in. You're going to really enjoy it. If you're trying to learn E2, if you've done E2, you have people who have done E2 for years. But when you just spend an hour seeing how I did it and you get a different perspective, and you got to understand, like, my perspective comes from all the stuff that people, listeners and colleagues share with me. So I have like a lot of data and information coming on my side that everyone doesn't get access to. And I use that time to share with everybody. Definitely worth your time. Secondly, another thing that's worth your time is free are the AEO decisions. We're using ChatGPT to break down the essence of AEO cases and then reviewing that and sharing the notes. So you could really quickly go through all the cases on these AEO decisions. All of them. We're still just beta testing on NIWs, L1s, EB1As, but there's thousands of those that are coming out. And it just gets really good. So I did the previous recording, number 366. I went over like a consultation I had, and I needed some extra information on how to deal with the national interest waiver, how it's being handled right now. And all I did is, I looked over the notes, and I do a video where I show how I did in the previous one. If you haven't saw it, check it out on YouTube. It's probably better to do it because I share my screen. But I found cases that resonate with the issues I had. I read those, and when I went into the consultation, I knocked it out, and I got the client that switched lawyers actually to come with me. And that's how powerful it is to know this kind of stuff, the confidence it gives, and the fine-tuned points they can provide to make your skills really good. And that's free just for lawyers. We have a registration page for that one. If you go to iltbox.com, immigrationlawyerstoolbox.com, whichever one, and there's a community page. In that community page, we have tons of CLEs, which I'm going to reference later in the show today, as well as white label content, which just the marketing content my law firm does. I'm like taking our logo out, so you could do it, a lot of it too. I have to add more to it because I get backed up, but it's all that free stuff. Videos, training, all this kind of stuff that you really knock your socks off. So check it out. I'm going to record an analysis of a couple of L1 decisions. This is probably next. I was going to do a podcast, but I want to do it private just for people that are members of the group. We have a couple hundred people where I have a L1 case I'm getting right now, an intracompany transfer, and we're going to be using a lot of foreign employees and not using as much US. So I want to see how they're dealing with it right now. So the recording is going to show how, like, I went through the cases, I found what I need, and I read those, and then I'm going to analyze, just aside from the ChatGPT AI kind of stuff, what my analysis of how to use foreign employees and what issues people had, to be mindful of that for your cases, because it's a great way to be able to get these L1 cases for small new offices in when the people don't have a lot of employees in the U.S. But you got to be mindful of showing certain things. I'm going to go over those facts and make sure you got to cover to have a strong case. So it's very powerful. You can make a whole practice just doing that kind of case. I used to have that. I just had no staff, so it was hard doing all these L1s. But new office L1s, it's so hard, but it's so good at the same time. So what's another thing? Our new magazine's out, issue 8, and number 9 is going to come out probably in 2 weeks. But check it out. Go to Toolbox. There's different websites for it, but just go to immigrationlawyerstoolbox.com and check out issue 8. We have some great colleagues, and I got to interview them about the articles they did on various topics, same-sex marriage, about issues with Indian cases being charged with alien smuggling, and a lot more. Definitely go to do that. And I also do want to thank our wonderful and special sponsor, Mitratech's Ina Zoom, who has been supporting the podcast, and they're doing some very novel stuff themselves over there with regard to AI, which is introduced in a session yesterday. Are you tired of wasting time on tedious data entry? Then it's time to streamline your immigration process with Mitratech Ina Zoom, the leading immigration management software trusted by top law firms and corporations worldwide. Meet Your Text AI Zoom helps you manage cases, track deadlines, and automate workflows so you can focus on what matters the most, your clients. But that's not all. And this is the big new announcement. Meet Your Text AI Zoom just launched Gov Notice IDP, GOV Notice IDP, a revolutionary AI-powered tool which automatically extracts critical information from your government notices and receipts. No more manual data entry, no more errors, no more headaches. Instead of traditional, highly mundane manual entry of USCIS notice receipt data, Gov Notice IDP automates the entire process, ensuring a faster, more error-free experience. Legal teams can upload batches of receipts in bulk with automated classification and case linking, reducing processing time significantly. Over 95% accuracy rate, 500 plus number of receipts processed per day. Option for automated email notification to stakeholders. That's really key because that's one problem we have in our firm is like we upload it now, we put it in our system, we have different tracking. But now to get team members to like send it out and sometimes we forget this and that. I mean, clients get them too. We always have, we don't mark on the G20 for us to get cases, but having the ability just to them do it is just, these notices come out is really good. And their current notice system is for USCIS receipt notices, including premium processing, as well as approval notices. When GovNotice IDP, you can process and manage your case faster and more efficiently than ever before. Ready to take your immigration practice to the next level? Learn more at hrc.meetyourtech.com/toolbox. That's hrc.meetyourtech.com/toolbox to learn more. So I want to thank you for that. And without further ado, let's let it start. As always, the information provided here is not intended as individual legal guidance. Please consult with an immigration attorney about your case, but you all know that already. All right, let's go number one. This is really interesting. It's about military citizenship. So I was contacted by a person who's about to get the green card lottery, and they're anxious to get citizenship, and they read online that if you sign up for the military as a green card holder, you could get citizenship immediately. I'm like, I don't know, it's the case. I do a lot of military cases, but military marriage cases. U.S. citizen goes to the military, and then they fall in love on base in South Korea or wherever they're stationed, and that kind of thing. But I was like, I'm gonna look into this, and apparently, in the first administration of Trump, they stopped this program where as soon as you register for the Army and you're you get the papers, you could immediately file for citizenship. Because the U.S. is at a state of ongoing war since 2000, you usually have to wait a year, but if you're ongoing war, you can do it immediately. And so people were doing that, filing for citizenship immediately, and Trump stopped that and said, no, you have to be able to essentially go through a year of basic training and finish a background checks before you could apply. Now, people sued on this, and the lawsuits are pending. I think the government was going to lose. I think the government lost. Yeah, the government lost. And so what the judge, though, said is you have to keep the same system. But then the Biden administration that came at that point, and the Biden administration said that, hold appeal. We're going to change this policy and update it to make it like, the way it's supposed to be or something like that. So, 3 years, 4 years go by. Biden administration is out now. Actually, before the Biden administration is ending, like a couple months before it, and this is, if you're listening to my podcast, I'm not a big fan of the Biden administration, especially immigration. It was just, to try to get votes. It wasn't really to help immigrants out in any way. Even it just was so ridiculous, but okay. So they say, actually, we're going to keep the Trump policy. So give us more time. We're going to file appeal. We're on board with the Trump policy that was with military naturalization. So they haven't, from what I haven't heard in the news, at least, so it's come to my attention that they've filed the appeal information. But Biden administration didn't get a chance to do it, I don't think. But obviously, Trump administration is probably something they want to do. They'll do again. So they're probably going to appeal it. So right now, when I'm recording this in February 2025, as soon as you join the military, you file for citizenship. But expect that to be challenged in the next 4 years and change. It was a whole rabbit hole I went down of law that I wasn't aware of. So glad I shared that information. Number two, this is like just insanity right now that you may have heard of all the Facebook groups. Sorry, just for those listening to audio, I was just grabbing a cup of coffee, a sip of coffee, is all this information about traveling and not be able to come back in. So I'm getting people freaking out saying I'm a green card holder, calling me like, I heard you can't come back in. There's this woman on TikTok who said her niece was able to re-enter the U.S. And as always, 99.9% of the time, the information that comes from people, they have no idea what's going on with the case. So that's bad. But there are some parts that are good and some people saying stuff I wouldn't expect. So first of all, they're saying that like if you have a green card, can't come back in. It's just not true. Now, as always, if you're out for more than 6 months, the government could ask you and consider you as an arriving alien to see why you've been absent and stuff like that. But practically, they never do that. After a year, they can take away the green card too and send you to immigration court unless you sign I-407 to kick you out. Sometimes you sign I-407 to give you a tourist visa to come back in. Maybe you could readjust like that. So strategically, it might be the thing to do. But But people are saying there's no SB1, there's no reentry permits. None of that's true. Some they say you can't be outside for more than 170 days in a year. That's wrong. And I even saw one TikTok lawyer that's really famous when it comes to marketing. He was saying that if you're a conditional permanent resident, you're only allowed to be outside the country for 4 months, which is kind of shocked that I don't remember reading anything in the CFR about that. And I read that pretty frequently. It's been a while, I guess, but I would have known about there's a rule like that. I contacted him and I'm still waiting for a response. I don't want to name him intentionally, but that was shocking. And the one example that seemed to is policy is there was like a person that had I-751 denied. They were in removal proceedings. While you're in removal proceedings, you're still a green card holder. It's gets the judge makes a decision. And then maybe the person had advanced parole too or something like that. But at CBP in Logan, the airport in Boston, they didn't allow him to reenter. And they said this is our policy, is national policy even too. So I mean, if someone's in removal proceedings, unless it's a life or death situation, they shouldn't be leaving anyway. So, but it's like not that's I-75 when removal proceedings is not like a typical kind of case. So ideally you just refile an I-75 on USCIS depending on what the situation is anyway. So, just a heads up, that's the only factual thing I can find so far of what's going on. Obviously, you never know. The government is some crazy stuff. It's there's thousands of officers, millions of interactions. There's going to be bad ones, but the social media on this one, like, takes out of consideration like the facts of it. There are also a word that people coming in on VAWA are getting questioned in secondary and like really into their case. There was just an arrest of a guy, the conviction of a guy in New York who was filing a bunch of fake VAWA cases for parents of U.S. citizen spouses. As you all know, the whole situation with VAWA, I've talked about it before, like how the numbers have spiked in the last 5 years, and there's a whole thing about that that y'all know, or if you don't know, you don't know. But I don't want to get into that. So they're questioning that airport. Unfortunately, that's that. But I haven't had issues with any of my clients traveling. Ideally, not at this point. You don't really want people to travel on TPS because, on advanced parole. I'm reorganizing in my head. I think I wanted to talk about, but maybe it's a good time to talk about it right now. So let me move this one part I was going to talk about the end to the beginning. So I'm not sure if this is point number 3 or 2B or something like that, but I have a consultation with a gentleman who has TPS, child permission, and he's going to do a marriage adjustment case, but he has to leave too. And it's going to take forever to get advanced parole on the marriage adjustment. Plus, I wanted to try on TPS to have that as a backup. So I was like, I can't tell him to travel. And so I posted on Facebook, and a kind friend, let me see if I can remember her. Someone first time hearing the name, but I want to give him the citation. It's Jesse M. Thomas. No, it's not Jesse, it's something else. How much time should I spend looking this up? Well, I want to thank them, whoever they know who they are, because as you should read the instructions for my 484, this scenario is in there. Because a lot of people say you can't do it. I don't think you can either. But if you go top of page 17, bottom of page 16, top of page 17, the section starts with if you're leaving the U.S. while your application is pending and you have adjustment of status, 245, not asylum judge status, but 245. Obviously, you all know the case is going to get voided if you leave. However, if you are a temporary protected status TPS beneficiary who travels with authorization under INA section 244F3, and upon returning, you're inspected and admitted into TPS, you could still keep your adjustment of status case. It's interesting to say admitted, not paroled here. So it's an admission, which is really good for other purposes like 245K or something like that. But that's a side note. So this is the same section where it says like H-1B, someone who has H-1B or L could travel even with the case pending. What was interesting here, we have another case we're consulting on where the H-1B was pending. It says you are H-1B or L1 who is maintaining lawful non-immigrant status and you return with a valid H-1. So I have a case where the H-1B is pending and it might expire while it's still pending, and you have that automatic continue authorization to work, I think, on it for 140 days or 100. I can't remember what the rules are, 120 days, whatever, 4 months. How's it all work? But I'm like, don't overstay the existing one till a new one's approved, because if it's not, it's better you leave while it's still valid and come back in. That's opening up a can of worms of explaining. But nonetheless, for those who have to deal with this, it's maintaining lawful status. We have lawful status and you leave and return, not like you overstay on age and you're coming back to new age. That could kill you on the adjustment status. But I'll leave it at that, not to go into too much detail. Number 4, we're going to go into a whole consular processing and Department of State section right now. I learned this of the Nigerian system, but this came other places. But they're updating the consular processing for interviews where instead of going on the interview date and doing the fingerprints and reviewing documents, they're separating out, they're bifurcating it, where you come on an earlier date. This happened in the UK and a lot of other countries now too. Nigeria, UK are the two I'm dealing with, but you schedule an appointment to go in and show your documents, maybe do the medical checkup right then, and then go immediately afterwards and do your document review. Once they know those are good, then you could go for an in-person interview for an immigrant visa interview. So they've separated that. It's a new system. They've also updated another new system when it comes to registering the appointment, and it's a mess. We have been dealing with it in Egypt. We're dealing with it in Nigeria with the website's glitches. It won't recognize their cases. I think it's like AVIT or something like that. So be prepared for that nonsense from happening. FYI, regarding Nigeria, it's huge. It's one of the worst delays in the world. We just got an F2A spouse of a green card holder case who was documentarily qualified November 2022. We just got the appointment notice last week. So essentially, I don't know, it's 2 years and 2 months to get a notice for appointment in April. So 2 years and 3 or 4 months, whatever the math is, in delay for an F2A case that's documentarily qualified. And then number 5, Romania was added to the visa waiver program. I think Qatar was just added like 2 months ago. Now this one. And this is number 5 or 6. I don't know which one to make it better. But there's, for those who are dealing with cases in Northern Europe, Northeast Europe, I'll read it right here. Immigrant visa consolidation of cases from Finland, Estonia, Lithuania, and Latvia. As of December 2nd, 2024, the U.S. embassies in Helsinki, Finland, Tallinn, Estonia, Vilnius, Lithuania, and Riga, Latvia ceased routine immigrant visa services. The U.S. Embassy in Stockholm, Sweden, has been designated to conduct IV services for these posts in the following categories: immediate relatives, family preference, employment-based, fiance, K, follow to join, asylum refugee, 90-93, and diversity visa. So FYI, if you're dealing with cases from Finland, Estonia, Lithuania, Latvia, they're not doing immigrant visa interviews there anymore. They all go to Sweden. So heads up when you're guiding your clients on that. And a quick heads up, I want to let you know that about our marriage green card course, the best marriage green card course out there. If you see how much attention to detail I have and how much I care about the nuance of law, this 15 hours to 18 hours of this stuff, plus written material of going through the 8 CFR, going through the INA, going through the forms, breaking down practical experience, breaking down where our contract looks the way it does, how to talk with clients, how to close the deal, how inadmissibility works, the 212 statute, going through it, and a lot more. It's the Ultimate Marriage Green Card course that you could join. We just had several students joining, so we're putting back our regular monthly office hours again soon. So you'll have a group session where you can talk once a month and just say what's going on in your office, questions about practice, law, and stuff, and I'll share my 15 years experience and all of the thousands of people I've talked with in this area. So it's again, accumulation of a lot of knowledge there that I'm sharing. If you're starting your practice, you're switching up, make a small firm, or even if you've got people in practice for 10, 15 years, but they want to learn my systems to see if they could, gain something. Imagine you learn one thing in there that could save you, like 10 hours a month of time is definitely worth it, or gives you an idea about a marketing system that can really take your firm next level. It's definitely worth it. So to get more information, schedule a private chat about it. Email me at info@immigrationlawyerstoolbox.com or go to the website, iltbox.com. There's a link there for the course, and you just put your information there. It gives you contact info, and I'll get notified to reach out to you. But it really is a game changer. I really like. I got to do a hard sell on, in a sense that it really is that good. And I've been redoing the recordings too and updating it and stuff. I'm really proud of the work that I think is going to really change your life and fast forward your life. So instead of spending 2, 3, 4 years learning stuff, you could, in a month, essentially sit down, watch the videos, and talk with me, and really speed up your life and get to where you need to go. So number 7, maybe, I-209F Ombudsman new stats. I got to do a whole separate podcast now. So the Ombudsman's office issued a report, and especially focused on the I-24 and how much of a mess that is. And I thought I did a separate podcast for the Toolbox on that, but I think I did a podcast or it was a video I did for my law firm instead. So I was like, I could redo it for Toolbox, which could count as an episode. That's not bad. But if y'all interested in these updates about what's going on in the I-24 system, just get an understanding of it, go to JQK Law I-24 Ombudsman and watch that there. It goes through statistics of what's going on with these horrible form called I-24 and the issues that are there. But I guess I'll leave it at that. And that number is all off now. But let's say number 7, 8, 9, 10. Let's say number 7. Okay, so this is really important. Where could your immigrant visa interview happen? And this kind of follows in line with this theme of consular processing. I should have just done a top 10 consular processing and took off the non-stuff. But, okay. Yeah, because the next one's that too. So usually the rule is, from what I know, is like wherever you're residing, that's where you have to go to your interview. for a for immigrant visa interview. However, it's not that harsh. So under 9 FAM, the Foreign Affairs Manual, 9 FAM 504.4-8, usual place of application. As a general rule for immigrant visas and diversity visa applicants, they should apply for a visa in the consular district where a resident and an applicant is physically present in a person is present in the United States is last foreign resident. So typically it's like wherever your residence is. But alternatively, unless the department directs otherwise, applicants may make their visa application in the consular section have jurisdiction over their place of physical presence. So not just like where they're actually residing, but just physically where they are, if the applicant can establish that they will be able to remain in the area for the period required to process that application. So if you could show you're being canned on a tourist visa and it's going to last you a year somehow, I don't know if they do a year tourist visas, you can do it there. And that's not including administrative processing. It's really just to get the interview. You must here it says also accept when so directed by the department an IV application. If the department tells them, yeah, that's fine. And then so that was really important in that section. There's more to it. I'm not sure how much I want to read. But essentially, if you're physically present there, you could do it. So if need be, you could contact them, either tell National Visa Center to move the case or contact embassy to embassy and ask them, depending on where the case is, to accept the case. Now, it's their discretion. They can say no as well. But it gives you some leeway to move stuff. Even if you're not there, you can always contact them and say, I'm going to be there. There's more flexibility than you think when it comes to this stuff. So if you need to, reach out to them and see what you can do. So I wanted to share that information. Number 7 again, or 8, let's say, Department of State wait times. And I actually have this. I'm going to share this. It's going to take too much time to share. I'll tell you how to do it. So as soon as Trump came, they changed the Department of State wait times. So if you just type in DOS wait times in Google, there was a page that came from Department of State. And it was like you put in the city where the consular section is that you want to do an interview. It's more for non-immigrant reviews, not for immigrant reviews, but B2, F1, all that kind of stuff. And it'll give you an estimate. An estimate was based on when a calendar opening they thought would open up, how many months from now. It was really kind of stupid way of looking at it because it may say, okay, in 6 months, the calendar time is going to open, but it could be a time that's 6 months from there. But as soon as the Trump administration came, the website went down. I'm like, oh, that sucks. They just took it off. Terrible. But they came back on. Actually, it's better than it was before because they just made this Excel sheet that has all the different consulates. And there's it's like an Excel sheet where the rows are the different cities and the columns are like if you have an interview required on F, M, or J, how many days, if it's H, L, O, P, Q, or crewman D or B2. So you can really quickly because before I have to figure out names of places, but now I can just scroll down and really quickly see, okay, which embassies are taking the most time. Like when I'm scrolling down right now, randomly, Seoul takes, let's look at tourist visa interviews because they're usually the most out of whack. So just right at the top, Abu Dhabi is 433 days for a B1, B2 interview. That's crazy. But quickly looking down, Amsterdam is 18 days. So it gives you perspective, and actually you can help me make a lot more charts and data that I can share with you for marketing purposes and say, does it have a date on when these are based on? Last updated January 7th. It's 2 months old, so it's probably crap data. But okay, so let's say it's good. I just want to share with you that change that happened. And then this is number 9 is really annoying. So all of a sudden in December, we submit our cases to USCIS, and we'd go online, and it would say on the receipt on USCIS.gov, you're tracking your case or my.uscis.gov, it would say 10 cases temporarily on hold because of the payment is not being processed. And I was like, what do you mean? It charged our card. It took the money, and then a week or two later, we'd get an updated notice, courtesy copy that said it went through, and that's happening to 10% of our cases or 5 or 10%. It's kind of, and now I know it's just, from the beginning, I knew US is messing up. The money went through. It should be okay. But it obviously scares clients and stuff like that. So be prepared if that comes up. That is happening. So it's something important to look for. And number 10, now I had that other I-485 thing about adjustment, about parole where I talked about, took it out of this section. But I have a twofer in this one. First of all, the I-693, which is the bane of my existence because doctors keep messing it up. They took away the COVID vaccine requirement and actually got a bad review on our podcast because someone got angry that I said it's bad that we took away the booster requirement. If someone wants to get a booster, God bless them, go get it. But we can't force people to do this stuff. I'm going to stick with that. It's too controversial. I don't care. But let them do it. And their theory in the comment section was that, these people might get abducted and detained and go there and they're going to get it. They could always get it on their own. You don't have to have an I-693 to get it. And frankly, a majority of people, almost all of them who are filing an I-485 and are required to an I-693, those are not people that are going to be detained. It's very rare because they have a path to sit to the residency. They're not on the priority list. So it's like, if they want to do it, it's fine, but to force them. So that 1-star review is ridiculous. People are ignorant. I'm sure a chunk of the immigration community probably agrees with that review, but whatever. I'll stick to my values. But if you want to get it, I'm happy that's not there. On the other hand, they're requiring polio shots now. And someone had posted that their case got denied because the person didn't get an updated polio shot. So then it's like, I didn't even know that was a requirement. And I studied, like, oh, all of a sudden, like 3 months ago, I said, oh, now you have to get a new polio shot. I'm like, dude, they don't update us. USCIS has announced this stuff. You got to go to CDC's website, study. I'm not a doctor. So I'm like changing policy. I'm saying now that USCIS is requiring that you submit the I-693 with initial application, we're not waiting for an RFE to send it in. Then USCIS has a chance where if there's a problem, the RFE has to let us know. So I'm not going to bother reading this darn thing anymore because like this is ridiculous how they change these rules and not telling us. On the other hand, too, especially because the doctors don't sign the documents and do them properly, and it's come a fight just getting to listen to what the rules are. Before, because we usually wouldn't send it with the application, we'd wait for the RFE, just get the case in faster. And at the RFE stage, if it came in bad and then it was bad, they deny the case. We haven't had that issue. But now I'm like, okay, we're sending with the case. If there's issues, they RFE us, and so we can fix it then. So I don't want to get involved in reading these because we got in a couple of fights with these doctors, and it's just like draining if to argue with people to do their job. So that's a heated topic right there for me. And 10B, tips of, so they updated the form I-485 to ask about unlawful presence. And the reason why I really hate that aspect is unlawful presence is a very technical legal term. And there's a 50-page policy manual update that has parts of itself that are outdated that you have no updates on. So long short of it is they want you to say if you've had unlawful presence days and what those days were, which is very difficult because people have no idea. We had one client who right before filing realized they had overstayed on one trip because their O1 got denied and they didn't know, so they were waiting here for a decision, and then they ended up staying for like 7 months out of status and accumulating unlawful presence days, and then they left. Now they were able to re-enter. They were Canadian, so it was very easy for them to come and go. And like 3 years had passed, so they updated the USCIS policy. They said you could run the clock for a 3 or 10-year bar while in the US. So it doesn't apply to them, but nonetheless, going into like all the details of talking to people about this and getting that information, it requires so much digging in, which we do for the most part before. But now we got to get the exact dates, and our clients are fighting us on it. It's just like a mess. And putting us aside our clients, but a lot of people are pro sacred following this, and a lot of immigration lawyers don't even know what lawful presence is. So I do have a very detailed free CLE. It's probably 60 minutes where I go over the 50-page memo of what unlawful presence is, 3 or 10-year bar, how that works. It's free on Circle SR community page. Just log in and go to the CLE page. And it's one of the videos there. I highly recommend doing that. I read that memo like 10 times before I understood it. So it's time consuming. It's like 50 pages again. So I do recommend reading it, but read along with what I'm saying there, help out. But it's very important to know because now it's part of the questions on the Form I-485. So you got to be very mindful. You don't want to send your clients in without having this stuff all in order and creating havoc for their lives. But that's top 10. As always, a lot of fun. And the last two got a little heated, but it is what it is. These are the kind of stuff we're putting out there. Join our community page, Circle. So if you're a lawyer, come to the E2 live seminars. We don't record them because we want to talk openly, so it's live. E2 NIW is coming in April. Learn how to do this. Get better at doing these. Get the marriage immigration course. Check out the magazine. All this content, almost all of it is free. Just putting it out there so you become a better immigration lawyer, raising the standards in the field. And again, thank you for our sponsor, Meet Your Tech Science Zoom, for the help they have to support this podcast and this program to keep it forward. Keep tuning in on the podcast. I'm immigration lawyer John Khosravi. Reach out, to send me some kudos or say I love your show or something like that. Not for my ego or anything like that, but just for the sake of, hey, I like to know who's listening. It helps me out, see the range. And as you all know, I'm interviewing people. I love talking with other immigration attorneys, so I love it. So having said all that, I'll see y'all soon. And I'm going to be in Chicago. I'm going to be in Jamaica probably for a conference coming up. So keep you posted on all this stuff, but I'll probably see you in Colorado for the national chamber. I think I'm just going to get I'm still figuring out because it's expensive, but just get a booth for the Toolbox because I don't go to any of the CLEs anyways. I just walk around and talk with people. So I'm like, is it worth paying $1,000 or $1,500 to go to CLEs, but I don't go to? Might as well just get a booth there and sit, and if people come to me, I'll talk with them. It's 4 days of talking nonstop, but I love it. And again, that's why I'm saying reach out to me, not to give you kudos, but just so that I like talking with listeners and talk about immigration law. That's why I've been doing this for how many years now? That's these 367 episodes. Thank you, everyone. God bless, be safe, and I'll see you all soon. Bye-bye.